Fellow Society is an organization of lawyers, judges, and students of conservative and libertarian-minded folks that are dedicated to fostering debate on a variety of different subjects. The purpose of the Fellow Society is to promote principles that the state exists to preserve freedom, that the separation of government powers is central to our Constitution. It is emphatically the province and duty of the judiciary to say what the law is and not what it should be. So today we have our annual SCOTUS Roundup. I will introduce our panelists here. We have Ilya Shapiro of the Cato Institute. He is the editor-in-chief of the Cato Supreme Court Review. If there's a Supreme Court case, he knows about it. To his right, we have Justice Massengale, who's joining us from just down the street at the First Court of Appeals here in Houston. And to his right, we have our very own Professor Blackman. So with that, guys.
Great. Stay here.
Whatever you want.
What about for your recording, Josh?
I think he's in the.
This is for the ISR.
Here's the frame.
Okay.
You're in the frame. Although
it's very important not to fall foul of
Professor
Blackman's audiovisual equipment.
Just put the mic here then.
Thanks for having me back. Clearly, this means my previous occasions I didn't make too much of a fool of myself, or you can't get anyone else to come. So either way, I'm happy to be your dining accompaniment. Kind of unusual, I guess. Y'all are coming up on your exams, Thanksgiving, and yet we're doing like a Supreme Court review preview, although really the court's just getting started. It's only had a couple of sittings, pretty low-key cases, and of course it's a whole new ballgame after the confirmation hearings and vote and all of that. But let's take a step back. The term that ended in June, before Justice Kennedy announced his retirement. This was the first full term with the court back at full strength after Justice Scalia's passing. So all eyes were on Justice Gorsuch to see how he'd fit in, whether that would affect the court's internal dynamic or voting patterns. While early reports, based on what turns out now to be unsubstantiated speculation, spoke of tensions between the newest justice and several of his colleagues, he quickly settled in and ended up writing many thoughtful opinions, casting several deciding votes, and actually he was assigned to write for the majority in 5 of the 5-4 decisions. There were 19 5-4 cases overall, and Gorsuch, more than anyone else, wrote 5. That's unusual. The last time a rookie justice wrote so many majority opinions in 5-4 cases was 1988-89, when the rookie justice was one Anthony Kennedy. So clearly, Justice Gorsuch at least has the confidence of Chief Justice Roberts and is quickly finding his stride. But Gorsuch's first full year was only part of what made this an interesting term. I don't know if I'd necessarily count any of the rulings as world historic, of the sort that we'll still be talking about a decade or more from now, but it was a year where a new court came together and there were several big, interesting cases, like Murphy versus NCAA about sports gambling and federalism, South Dakota versus Wayfair, state taxes on internet commerce, NIFLA versus Becerra, compelled speech at crisis pregnancy centers. We cover them all in the Cato Supreme Court Review, and we're going to cover them on this panel. But it's unclear what effect they have beyond the immediate facts on the ground. Even Trump versus Hawaii, travel ban 3.0, while igniting millions of Twitter wars, doesn't really break new ground, given the broad discretion that Congress gives the executive on immigration and the deference that courts give the president on matters of national security. And recall that most experts were predicting that that case would be more than 5-4, that the administration would win by more. And really, it was, because Justice Breyer, joined by Justice Kagan, merely filed a technocratic opinion about needing more evidence to be able to decide, declining to enlist in what I call the judicial resistance. That only garnered 2 votes, Sotomayor and Ginsburg, sort of treating this case as different because it's a different kind of president, but Josh will go into that. The cases that arguably had the greatest potential for changing the legal landscape, Masterpiece Cake Shop and Gill v. Whitford, partisan gerrymandering, fizzled. And so probably the longest lasting rulings were Carpenter versus United States about the police needing a warrant to collect cell phone location data, and Janus versus AFSCME about public sector unions not being able to charge fees to non-members. So there was a lot going on in many fields of law. But the court was really playing second fiddle to whatever was going on in the political world or the president's Twitter feed or what have you. Until Wednesday, June 27th, the last day of term, and coincidentally my birthday. And like most people in Washington, I spent my birthday testifying before the Federal Election Commission while monitoring my phone on SCOTUS blog to see, of course, Janus was going to come down. We knew that. I had pre-prepared statements, whether it went yay or nay. But also, would there be any retirements? And there wasn't that morning from the bench. There were not any retirements. So I went back to my office and I kind of turned on the World Cup, put my feet up, took out that stack of opinions from the previous week of the court every day deciding several interesting things. I thought I'd have a nice little nerdy birthday, except a couple of hours later I get a call from the CBS producer saying, get yourself in front of a camera, let's talk about Justice Kennedy's retiring. I'm like, okay, here we go. Kennedy had long been the court's swing vote, meaning he was most often the majority in those 5-4 cases that split along conventional ideological lines, although he hated that term. He said, the cases swing, I don't. Well, this term there were 19, as I said, 5-4 decisions, just over a quarter of the total. That's about normal. Of those 19, 15 had Kennedy joining the conservatives, and none had him joining the liberals. That's really unusual. In fact, it's never happened since Kennedy became the definitive man in the middle when Justice O'Connor retired and was replaced with Justice Alito. Now, I don't think it's that Kennedy in his final year, what he knew was going to be his final year, decided, well, I need to establish my conservative bona fides by doing that. And it's too simplistic, I think, to characterize particular terms as liberal, conservative, or anything else. There was, a few years ago, you might recall, a libertarian moment at the court. Cato did really well in our amicus program. We got a lot of donations. That was great, but I really don't think it's that every summer the justices decide collectively or separately, oh yeah, we're going to turn left or right or whatever, just a function of the serendipity of the cases. And so this term really gave progressives plenty of heartburn. And now it should only get worse for them because President Trump has followed through on his promise to pick from his fabulous list of terrific judges. You're going to love these judges. They're the best, believe me. I'm not going to do the voice, just the hand signal. And Justice Kavanaugh's confirmation means that the Chief Justice is the median vote. We haven't had the Chief Justice be in the middle of the court jurisprudentially since, I think, the 30s. So this is something new. And I don't want to oversell the point. John Roberts will have even more incentive to indulge his minimalist fantasies to lead the court from the squishy commanding heights.
Indulge fancy squishy, really?
Yep.
Like.
I find nothing strange about that. I don't know what websites you peruse, Professor Blackman. But anyway, incrementalist, judicial, minimalist restraint and all, Roberts is a far surer vote for conservatives, maybe not necessarily libertarians, than Kennedy ever was. Although the last two terms, Roberts actually voted with Cato slightly more than Kennedy did. So maybe he's evolving in office in Cato's direction. We'll see. And so President Trump, who wouldn't have won the election had it not been for the Scalia vacancy, has now ensured that his substantive legacy will be in the judicial realm. That's, I don't know, pick an adjective. Amazing, ironic, certainly interesting. And having appointed an eighth of all federal circuit judges in less than 18 months and a record 29 to date, that's more than Bush and Obama at this point in their presidencies combined. He's now had back-to-back Supreme Court appointments. And Justice Ginsburg, who's 80, Breyer, who's 85, Breyer, who's 80, and Thomas, who's 70 and maybe getting restless, aren't getting any younger. So we may see more opportunities, especially given the larger Republican Senate majority. So this term, while starting slowly, ended up giving a lot to those who want the law applied as written and see constitutional structure as a protector of liberty. But we're just getting started. All right, I'm going to save some of these statistics that'll make you really popular at bar review, perhaps for later chit-chat if there's a dearth of questions, and jump right into the cases that I've been assigned to cover. So first, Murphy versus NCAA. And it's unfortunate that New Jersey had a gubernatorial election in the middle of this litigation, because before that it was Chris Christie versus NCAA, which is kind of like the Iran-Iraq war. You want both sides to lose, right? But this case, what a lot of, what most people thought was about sports gambling, we lawyers knew was about federalism, but it turns out the Supreme Court told us it was about severability. Right? So the issue here, I'll describe momentarily, the issue here is the Professional and Amateur Sports Protection Act of 1992, which prohibits states from authorizing by law sports betting, although it grandfathered in the state of Nevada, surprise, surprise, and a couple of sports lotteries that pre-existed the law. There's also a one-year safe harbor. So if any state wanted to legalize sports gambling, they had that chance. New Jersey missed that safe harbor by 20 years. So when its legislature in 2012 decided to legalize and regulate sports gambling, there was this case pitting New Jersey against the major professional sports leagues, the NCAA, and the U.S. government, and Congress. Seemed like an easy case to decide under what's called the anti-commandeering doctrine, meaning the federal government may or may not be able to regulate in a given area, the Interstate Commerce Clause or whatever else, but it can't force states to enforce those laws. And so whenever you see state law enforcement, for example, enforcing federal law, that's voluntarily. That's because that police department or municipality or state has an agreement with the federal government to enforce those particular laws. And that's the case whether it's criminal law or immigration or marijuana. I mean, you see these kind of federalism tensions or cooperations in a whole host of public policy areas. And so, as I said, the court found this to be an easy issue. Leaving aside the question of whether Congress could, if it wanted to, regulate or ban sports gambling around the country, it can't regulate on the cheap, as Justice Alito put it, for the majority, and force states to either keep their criminalizations or pass new ones or what have you. And on that question, the anti-commandeering question, the vote was 7-0. There was no dissent from the point that PASPA, this law, unconstitutionally told states what to do, which was interesting because there hadn't been an anti-commandeering case in about 20 years. But as I said, the bigger debate, it turns out, was on severability, because there are other provisions in PASPA, and the question was, did the entire law have to fall? And here the vote was 7-2, with Justices Ginsburg and Sotomayor in dissent. But anyway, if you do, if you're looking at any big comprehensive pieces of legislation and you're thinking about whether all of it has to fall, if part of it is declared unconstitutional, you might recall the debate over that when Obamacare was being litigated. But anyway, this is now the latest and greatest exposition, and Alito goes into what courts are to look at when dealing with severability. Moving to the criminal law, the Carpenter case that I mentioned. So there were a string of robberies in the Detroit metro area. The police had some suspects, but they didn't have probable cause to arrest anyone. But they wanted to get the location data of people they thought might be involved in these robberies. Ironically, the robberies were of cell phone stores and Radio Shacks. And so they, pursuant to a subpoena under the Federal Stored Communications Act, they went to the cell phone providers, Sprint, Verizon, AT&T, etc., and asked for the records for the particular people they were looking into. And ding, 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 they found that the people were in the vicinities of these robberies, and away they went. They eventually prosecuted and convicted these folks. Timothy Carpenter, one of them, said, look, this violates my Fourth Amendment rights. You are looking at data that's my own personal data. I have an agreement with the cell phone provider not to reveal it, and so you really should have gotten a warrant. And it poses an interesting question of two pretty settled doctrines of constitutional criminal procedure. One is the reasonable expectation of privacy, which is over 50 years old, from the Katz case in 1967, that says that there's no Fourth Amendment violation if you didn't have a reasonable expectation of privacy in something. If you're, out in the middle of the street, yelling out your, banking information or health information or whatever, the police can listen to you and report that, or having a loud conversation or something like that. Well, here, do we really have a reasonable expectation of privacy in this data that's being pinged off from these mini computers in our pockets and purses to the cell phone location towers? And also, furthermore, the third-party doctrine. If I give my data, my information, my personal effects to Justice Massengale here, well, the police can search him if they're properly searching him and find it, and my rights are not violated because I've given the stuff to a third party. And here, similarly, it's the cell phone providers that are recording this data. It doesn't stay on his phone. It's not recorded, at his house. Well, unless you have your own personal servers in your basement or something like that. But anyway, I filed a brief, Cato filed a brief supporting Mr. Carpenter here. And even though ultimately the court did rule 5-4 in his favor, it was kind of unsatisfying. Chief Justice Roberts basically waved his hands and said, well, this is close enough to an expectation of privacy. It's not really a true third party. It's kind of somewhere in the middle. Good enough for government work. Or not good enough for government work. Go get a warrant. What's really interesting here, I think the dissenters do well to poke holes in that kind of woolly reasoning. But the real interesting writing here is by Justice Gorsuch, nominally in dissent, but only because he says that Mr. Carpenter's lawyers didn't raise the original public meaning of the Fourth Amendment. That is, these doctrines that I've been discussing, reasonable expectation of privacy, third-party doctrine, they're judge-made. That's not in the Constitution. Maybe we need to look, Justice Gorsuch says, at what personal papers and effects means, what is an unreasonable search in the digital age, that sort of thing. And when you combine that with Justice Sotomayor's concurrence in the GPS tracking case, United States versus Jones, from about 5 years ago, I think you have the rudiments of where constitutional criminal procedure will be going in some future case. Here, it was limited to just cell phone location data. And finally, the last case from the term that I want to talk about is Masterpiece Cake Shop. There were a lot of ways to slice this case. I don't want to I don't want to over-yoke the analysis. Some people thought the ruling was sweet, but ultimately I think it was a lot of empty calories.
He's half-baked.
I'm sure you're familiar with the facts. A baker in Colorado didn't want to bake a cake for a gay wedding. Actually, it was a gay commitment ceremony. This is before Colorado actually had gay marriage. This is before Obergefell, the facts of this case. But anyway, the Civil Rights Commission ultimately prosecuted him for violating anti-discrimination laws, raising all sorts of questions. Can you get a First Amendment exemption from anti-discrimination laws? Does it matter that your objection has a religious basis? What role does compelled speech play in this? Is a baker a type of expressive professional who could even assert a compelled speech claim? Is there a difference between not willing to serve a class of people and not willing to contribute a particular item for a particular event? All of these questions, fascinating. The Supreme Court decided none of them. Ultimately, by a 7-2 vote, with Justice Kennedy writing for the majority, found that the Civil Rights Commission itself had displayed anti-religious animus, and therefore Mr. Phillips's equal protection rights were violated. Kicking the can down the road, ultimately, if this was a punt, and I do think that it was kind of a failure of nerve on Justice Kennedy's part, he's known as very strong on free speech, very strong on gay rights. How do you reconcile them? Well, Cato finds it very easy to reconcile them by looking at whether it's public action or private action, but I guess Cato is not a big enough constituency for Justice Kennedy and decided to retire without disappointing one of his groups of fans. But we have many of these cases coming up right behind, so if it was a punt, it was a shank. They didn't punt it very far. One commentator, Tom Berg, who along with Doug Laycock and myself are the only 3 lawyers to have filed in the country to have filed briefs supporting both Jim Obergefell in the marriage wars and Jack Phillips here. He commented that this was a Romer for religious believers. Romer versus Evans is a case from 20 years ago, also out of Colorado, that said that a government action based on anti-gay animus was improper. So similarly here, government action based on anti-religious animus is improper. All right, coming to next term, or really this term that we're in now, I'd say none of the cases thus far that are on the docket reach the kind of general news appeal of the top half dozen or so from last term. We'll go into a few of them. A handful of them actually were argued the first week of the term when Justice Kavanaugh was not yet confirmed, so several of them might be re-argued, or there might be a 4-4 decision released, just affirming without opinion, or who knows what will happen. And one of these is Gundy versus United States, which could herald the resurrection of the anti-delegation doctrine, the non-delegation doctrine, which says that Congress cannot delegate its legislative powers to another branch. In our history, only 2 times has the Supreme Court struck down a federal law on non-delegation grounds. The last time was 1935, but they took this case. It involves the Federal Sex Offender Registry, SORNA, which delegated authority to the Attorney General to issue all sorts of regulations about whether registration should be retrospective, who has to register in certain contexts. Anyway, pretty broad powers in that regard. Based on the way argument went, again, this could be one of these 4-4s, or there could be some sort of Roberts getting together with Kagan to find some common squishy ground in the middle there. But we shall see. Definitely an interesting one for constitutional junkies. But of course, before we got to this term, we were occupied with a battle over the successor to Justice Kennedy, and Brett Kavanaugh is kind of a standard conservative pick. He was picked in part because they thought he'd be easier to confirm than many of the others on the list, perhaps ironically. Somewhat of an odd choice for this president because Kavanaugh is an inside the Beltway double Ivy swamp creature. But nevertheless, very respected judge, a dozen years on the D.C. Circuit, more than anyone else on the current court when they were elevated. He's demonstrated a devotion to legal text and constitutional principle. His opinions are scholarly and cited all over the country, including by the Supreme Court. Maybe Justice Kennedy rubbed off on him when he was clerking for him, especially in the role of constitutional structure. Kavanaugh repeated again and again at his confirmation hearings, and even in his announcement of his nomination, that separation of powers protects individual liberty. Perhaps most notably, Kavanaugh's willingness to push back on the excesses of the regulatory state make him a man for the moment. I hope that he joins Justice Gorsuch, who's also known for that in a somewhat different way, in a project to make judges less deferential to administrative agencies. Now, there will be cases where Justice Kavanaugh and Cato don't see eye to eye. He's not a libertarian. But I do hope that in those politically sensitive times where Chief Justice Roberts might be inclined to tweak or rewrite a statute in order to save it, that Kavanaugh will be more like Justice Scalia and let the political chips fall where they may. After a bruising confirmation battle, one could expect no less. Thanks.
It's a pleasure to see you. I think almost all of you were in my class at some point, or will be in my class perhaps in the future. Illy and I are good friends. We do this all over the country. We have a traveling dog and pony show. So I'm grateful to be here. And also my good friend Justice Massengale. We are so fortunate to have him here as well tonight. Because Illy went long, I'll keep myself short. I'll talk about one case, and an important case. In fact, I'm teaching it tonight in con law. So if you want to come, you're welcome to come. It's at 7:30 till 9:30 from 518. And that case is called Trump against Hawaii. Usually, when landmark cases that present foundational questions come to the Supreme Court, they take several years, right? Think of NFIB versus Sebelius, the Obamacare case. That took almost 3 years.
That was an unprecedented case.
It was unprecedented. The nation unraveled my talk. Thank you very much. Obergefell v. Hodges took nearly 2 years. And during that deliberative process, advocates on both sides of the issue developed carefully crafted litigation strategies. Now, other types of SCOTUS cases come after major crises. Think of Bush v. Gore. That case raced the Supreme Court in about 3 weeks after the 2000 presidential election. Think also the steel seizure case, Youngstown, right? Less than 2 months after President Truman ordered the seizure of the steel mills, it came to the court, and the court issued a very fractured and divided opinion without everyone writing their own separate opinions. But these sorts of second cases arose from true emergencies, where the judiciary mobilized in response to an actual emergency that they had to confront. Okay? Trump against Hawaii fits into neither category. The legal issues in the case were not difficult, and the circumstances were not exigent. Without question, the president has the statutory and the constitutional authority to deny entry to aliens from certain countries based on national security concerns. Yet the judiciary still moved at warp speed to halt President Trump's signature policy. Why? The travel bans, which denied entry to aliens from predominantly Muslim nations, traced their roots to overtly anti-Muslim statements made by then-candidate Trump. Furthermore, the government could only offer the faintest patina of a rational basis to defend the policies. And confronted with these facts, the lower courts uniformly enjoined the travel bans. Ultimately, the court upheld the final version, Travel Ban 3.0, and it did so after an 18-month litigation blitz. So let's talk a little bit about the history of this policy. Less than a week after President Trump took the oath of office, he signed the first iteration of the travel ban. He calls it the Stephen Miller special, right? It was basically drafted in the back of a cocktail napkin. This was a very poor document that was not fully vetted. The effect of the policy was to deny entry to aliens from 7 predominantly Muslim nations, and in fact, it was announced on a Friday afternoon without any heads up. People who were on planes, when they boarded, they had permission to enter. When they landed in airports in coastal cities, they didn't have permission anymore, and they were being detained at the airports. Soon, judges intervened. They granted writs of habeas corpus to ensure these people could enter. But that was only the first wave in what I call the legal resistance to President Trump. Soon, more lawsuits were brought. And the Washington Attorney General secured a universal, not just nationwide, not global, but a universal injunction barring
That's a whole new meaning to alien.
I know, they're illegal aliens, like Men in Black, right? So the court granted a district court granted a universal injunction halting Travel Ban 1.0. At that point, the Trump administration didn't bother appealing to the Supreme Court because they were going to lose, and they went back to the drawing board and they drafted what became known as Travel Ban 2.0. Once again, the lower courts consistently ruled against President Trump. This time they went to the Supreme Court, and the Supreme Court sort of split the difference. They allowed part of the ban to go into effect, and they halted other parts. But this was always temporary. Travel Ban 3.0 became the final version of the policy. Once again, the lower courts enjoined it, and once again, it went to the Supreme Court. But then something very important happened. The Supreme Court allowed, on a temporary basis, the entire policy to go into effect. Generally, when the court allows a policy to go into effect on an interim basis, that's a signal that it will allow the entire policy to go into effect on a permanent basis. So once the court in December of 2017 allowed the travel ban to go into effect, I'm like, okay, Trump won, right? I was one of the people who earlier said predictably they win, and I think I was right. But then it goes to the Supreme Court. And I was actually at oral argument for the Supreme Court. I was actually at the court the day Kennedy retired. And I'll tell you a funny story. I'll come back to the case in a minute. If you go to oral arguments at the Supreme Court, you're facing forward. The bench is there. On the left side is where the press sits. And on the right side is where the family members of the justices sit. So, of course, I'm sitting in the front where the members of the bar sit. I'm sitting right next to the reporters, right? And what are the reporters doing? They're watching the family section to see what family members of the justices walk in on the last day of the term. Because generally, if someone's retiring, you want to bring your family in. So you see Justice Breyer's wife walk in. Hey, that's nice. And then Justice Alito's wife walks in. And then you see Justice Kennedy's wife walk in. And Justice Kennedy's son walk in. And his grandkids walk in. Hey. So one of the reporters who will remain nameless said, OF. Because once she saw Kennedy's wife and grandkids walk, she's like, oh, I know what that means, right? And then, here comes the kicker. On the last day of the term, the chief always announces retirements, who retired. And the chief said 2 names, and I didn't know the names. They didn't mean anything to me. It's like, all right, whatever. Not Kennedy, right? The name he announced was Kennedy's executive assistant. Oh. If I had known that name, I'm disappointed I didn't. I was on, okay, that's something's up. So, I left the court, talking to all the reporters, Supreme Court, people in Times, and Post. I'm like, yeah, I guess it's kind of a boring end of term. Kennedy's sticking around. And then, I say, well, just wait till the end of the day. And, I get in an Uber, going wherever I'm going. And then I get the news that Kennedy delivered a letter to the White House and said, I'm retired. So I was like, okay, I was there for my last thing. Arlene, were you there, right? Arlene, my Langdell this semester, was actually there for the last thing. So you were the last person just about to see Justice Kennedy on the bench. So, good, you did it. She got to, what time did you get there, 4 in the morning? Yeah. I told her to get there early, probably too early, but you got it. It was worth it? It was worth it. Yeah, that's what I like to hear. So, I'm spreading the gospel. Anyway, back to the travel ban. So, the last thing that Anthony Kennedy wrote as a member of the Supreme Court was actually his concurring opinion in Trump against Hawaii. The majority upheld it on fairly predictable grounds. The president has broad power to exclude people. You don't apply domestic establishment clause precedents to foreign policy decisions. And, we don't particularly like Trump, the court suggests as much, but this is about the presidency and not the president. And let me focus on Kennedy for a minute. I'll shut up and let Michael talk for the rest of the time. Justice Kennedy had this one colloquy during the oral argument where he asked, what happens if there's a person running for mayor of a city? And that person makes all these, racist and bigoted statements on the campaign trail. And then once he's elected, you know what, never mind, I don't think that anymore, but I'm going to not allow, people from certain countries to be serving on city council, right? Would you hesitate for a minute to say that that action violates the 14th Amendment? I think the answer is no. But Kennedy, I think, treats the mayor differently than he would treat the president. And if you read his concurring opinion, it's fairly brief, it's a couple pages. He says that the president's in a unique position, unlike anyone else in our central government. And the sorts of rules that do apply to the president, I think do apply to poor folk like us, don't always apply to the president. He has unique authorities. He's not above the law, but the law is applied differently to him. He can pardon people, he can issue, he can nominate people, he can fire people, he can do certain things. So I think the Kennedy concurrence reflects the fact that as much as people do and do not like the president, and living in Harris County, looking at the electoral returns, I can estimate where we are. The court at least recognized that he was still president and is entitled to have the powers to be exercised as president, and they should not be disabled from doing so through the course of litigation. And I think Kennedy put his money where his mouth is, in that he retired with President Trump appointing his replacement. He could have held on for a couple more years, so he seemed to be in good health, and maybe let a Democratic president replace him, but he trusted Trump. For better or worse, I think that's where the court is on the president, and I think that's where the court will remain to be with Kavanaugh in tow. I'll shut up now, and turn over to my good friend Justice Massengale, and I welcome any of your questions later. Thank you all so much.
Well, good evening. My name is Michael Massengale. Thrilled to be back in this building. For those of you who don't know, until about 5-6 years ago, the 1st and the 14th Courts of Appeals, which are intermediate state courts of appeals here in Texas, made their home in this building. And so when I was appointed to the court in 2009, this is where I came to work every day, and it was a lot of fun to mix and mingle with students walking into the building. It's a dynamic that I miss. And I've had the opportunity to talk to the Federal Society in this room many times, so I'm delighted to be invited back. I wanted to thank Kyle for giving me this opportunity, and also Josh and Ilya. These two guys are really some of the leading young scholars commenting on the courts in the country. These are guys that I follow closely online. They are really making a huge impact on our legal culture. And so it was a real privilege for me to be invited. I'm just thrilled to be here with y'all. Before I talk about the 2 cases assigned to me, I can't resist commenting on one aspect of the Trump case that Josh may have deliberately left for further discussion, and that is the entire notion of the legitimacy of a federal district court imposing a universal or nationwide injunction. This is a matter that has kind of become a hot topic. It's one that Justice Thomas has questioned explicitly in his concurring opinion in the Trump case. It's one that's going to be a centerpiece of the upcoming Federal Society National Lawyers Convention at the end of this week. And I think Justice Thomas raised some very, very perceptive concerns. He noted in his concurrence that these injunctions are beginning to take a toll for courts and for the executive branch. This is a subject that is being raised in every interview of a potential candidate for an appointment to a federal district court in the country. This is one of the really fascinating things about being a lawyer, and to think that over 250 years after our country was founded and with all this experience under the Constitution, we still have fascinating legal issues developing, and they're really not being discussed anywhere better than within the Federal Society. And I just, again, want to commend these two because you might hear, everybody here is mostly a law student, and you may hear people dismiss the Federal Society as just another club, and everybody thinks here alike. And I can attest, as a person who's been actively involved in the Federal Society for over 20 years, that scholars like Josh and Ilya are actually challenging a lot of orthodoxy views within the Federal Society. They are bringing really interesting ideas to bear and causing people to reconsider some long-held beliefs. And this is where the real debate about the law is happening, I think. There's no other institution. The ABA doesn't have real debate on the important issues the way we do in the Federal Society. So I thank you guys for everything you're doing.
And also the puns.
The puns, well, this is one of the ways in which I'm at an extreme disadvantage, because these guys, I complained mockingly that I was at a disadvantage because they can fall out of bed and do a panel like this. They do it all the time, and I would love to have the luxury of reading these cases when they come down the way they do. But I didn't fully understand how much I'd been hometowned until I sat down this weekend and I realized that the two cases Ilya had assigned to me, he had filed amicus briefs in the United States Supreme Court. So he's laid a trap for me, but I'll lay the cases out, and then we can see if there's going to be some interesting discussion about them. First case I'm going to talk about is South Dakota versus Wayfair, and this is an important case that really impacts revenue for all the states around the country, because it has to do with the important question of whether these online retailers that so many of us buy all of our stuff from these days can charge us sales tax, or can be required to collect a sales tax from us and remit it to the state. So this opinion turned out to be not only important to decide that question, but also it previews some interesting debates coming for the court relating to the dormant or negative commerce clause, and also how stare decisis principles are going to be applied by the court, which I think people will be watching in an era where we have new members of the court and perception of some shift of ideology on the court. So let me start by giving you just a quick background that you need to know to appreciate the legal issues. There are two cases that were in the crosshairs, one called Bellis-Hess from 1967 and another called Quill from 1992. So interestingly, cases on quarter-century intervals, all relating to the question of whether a state can collect sales tax revenue from an out-of-state retailer that lacks a physical presence in the taxing jurisdiction. So in the case of South Dakota, which is the state at issue here, if Amazon has, and Amazon's actually a bad example for reasons I'll get to in a second, but if Amazon has no physical presence in South Dakota yet is selling lots of goods into South Dakota, can South Dakota require Amazon to collect a sales tax and remit it? Well, this rule that a physical presence would be required was announced 50 years ago in Bellis-Hess. It was reaffirmed 25 years ago in the Quill case. And when Quill was decided, 3 justices, Scalia, Kennedy, and Thomas, all expressly based their agreement on stare decisis grounds. And it came up once again. Now, states rely many states, not all states, but many states rely very heavily on sales taxes for their revenue. And as a complement, in light of the fact that a state cannot require a sales tax to be collected and paid from an out-of-state retailer with no physical presence, there's a complementary taxing scheme known as a use tax. And it wouldn't be a surprise if none of you have any idea what a use tax is. I actually have a good story about this because I've paid a use tax, and I don't know anybody else who has. But the use tax kicks in when a sales tax can't be collected. And so in most jurisdictions, Texas included, if you buy something from a retailer and they don't charge you sales tax, you didn't just get off scot-free. You're legally required to pay the tax yourself. It's use tax. The problem is it's exceptionally difficult, almost impossible, to collect those use taxes. And so from the state's perspective, every sale, taxable sale that's happening where sales tax isn't being collected is lost tax revenue in the form of these use taxes that aren't being collected. So when Justice Kennedy, in a concurring opinion in 2015, mused that perhaps he would be interested in revisiting this question, South Dakota sprung into action. And they passed emergency legislation that's intended to apply sales and use tax obligations to the limits permitted by federal law. And so what their law said is that if any retailer sells more than $100,000 worth of goods or services into the state, or engages in 200 or more separate transactions to deliver goods or services into the state, then they're responsible to collect and remit the sales tax. And this was pretty carefully and thoughtfully designed, I think, to present this challenge for the Supreme Court to get it there. And the case was decided in an opinion written by Justice Kennedy. It's a 5-4 decision in an unusual alignment of the justices that I'll come back to. But they chose to overrule Bellis, Hess, and Quill. They eliminated the previously applicable per se physical presence rule. And they remanded the case for further proceedings because there's another doctrine called the complete auto test. It's a 4-part test that's used to evaluate when a state tax impermissibly interferes with interstate commerce. And so having cleared this hurdle of the physical presence bar, the rest of the parts of the complete auto test still have to be evaluated. Now, the court was actually unanimous, despite being split 5-4. The court was unanimous in concluding that Bellis Hess and its physical presence rule were wrongly decided. But the split came over whether or not to change course and reverse the court's prior precedent. And Justice Kennedy focused on a couple of particular things to justify changing the rules or correcting the error of the last 50 years. He emphasized the harmful effects that this ruling has caused to the marketplace, talked about how the impact of the internet economy was something that couldn't have been anticipated by the court, empathized with the states who have suffered this revenue shortfall, which has significantly increased over the last 50 years. There was a lot of debate about the numbers, but it's estimated to be between $8 and $33 billion a year that the states are unable to collect due to this rule. And he noted sort of the possibility that this was going to become a more difficult rule to administer in light of arguments that, well, maybe there is a physical presence for some of these internet retailers, considering that their cookies consist of data that get downloaded onto people's hard drives, that the purchasers may be downloading apps onto their phones, and they're present on the phones. Not that that's necessarily a winner, but it does make it a little more complicated. Considering what reliance interests people might have in the previous rule, Justice Kennedy was clearly unsympathetic to what he viewed as a massive tax avoidance system that all these retailers were encouraging. In fact, expressly touting on their websites that, you know, their pricing advantage, that we don't have to charge you any sales tax. And he viewed the burden of compliance with this as minimal. Chief Justice Roberts wrote the dissent. He thought the court should not reverse its precedent. He pointed out this is the third time the same issue has been before the court. He noted that when the issue came up the second time in Quill, that the court had expressly bounced this issue into Congress's court, that Congress always has had the ability to directly regulate this issue and has failed to do so, and so that could even be considered a type of acquiescence. Not only that, but Congress actually has invested a fair amount of effort into evaluating whether to alter the Bellis-Hess rule. So changing the precedent, having the court change the precedent, actually undermines all the efforts underway. And then finally, he pointed out that the problem may be fixing itself because a company like Amazon is actually now in the position where they are collecting and paying the sales taxes. I think this got pitched as something altruistic by Amazon, but I think the reality of it is that Amazon, by vertically integrating and having its own delivery function in all the states where it delivers, had already subjected itself to having a physical presence, so they're going to be paying the tax anyway. A couple of interesting points about this opinion. First of all, Justice Thomas wrote separately to reemphasize his rejection of the negative Commerce Clause jurisprudence.
He's perfect.
Well, interestingly, your hero, Justice Willett, I think, is also in the Thomas camp on this one.
Well, I know Gorsuch is. It's the only thing thus far in which I've disagreed with Gorsuch.
So Gorsuch also wrote separately to voice his skepticism about negative or dormant Commerce Clause, and he also sort of laid out the agenda. He outlined some issues that he'd like to see raised in future cases. So his suggested future avenues of attack include a distinction between the Commerce Clause's authorization for Congress to regulate commerce versus the implementation of the negative Commerce Clause, which is implemented by courts, which are in the position of invalidating state laws that offend no congressional statute. Justice Gorsuch also asks whether negative Commerce Clause is justified by stare decisis, or whether it can be defended, and this one requires deep thought, defended as a misbranded product of federalism or anti-discrimination imperatives flowing from Article 4's Privileges and Immunities Clause. So these, as he said, are questions for another day, and I think we can expect to see those challenges brought, especially with a new judge coming to the court. Last thing I wanted to observe about this is Justice Ginsburg actually joined the other traditional conservatives to form the majority for this opinion. It was Chief Justice Roberts joining with Breyer, Sotomayor, and Kagan to form the four-justice minority that would have applied stare decisis not to change the rule. And considering the attention that I think there will be on what the new court's attitude is going to be about implementing stare decisis, this could be a preview of a block we'll see more of in the future. Justice Roberts, Chief Justice Roberts, as the new swing vote, paired with the more liberal members of the court when he's not in agreement with where the conservatives want to go. So let me quickly touch on the other case that was assigned to me. This is the NIFLA case. NIFLA is National Institute of Family and Life Advocates. It's NIFLA versus Becerra, and this is a case about First Amendment as applied to crisis pregnancy centers in California. The crisis pregnancy centers brought a First Amendment challenge to a statute passed by California. It's the California Reproductive Freedom, Accountability, Comprehensive Care, and Transparency Act, or the FACT Act. The speech regulations in the crosshairs relate to two categories of crisis pregnancy centers as identified under this statute. They call them licensed clinics and unlicensed clinics. And with respect to both categories, the statute required these crisis pregnancy centers to give notices to women, patients, or clients, however you want to characterize them, in a form that was precisely scripted or dictated by the state. So with respect to the licensed covered facilities, there was a notice required that that had to be given to the women, the pregnant women, that California has public programs that provide immediate, free, or low-cost access to comprehensive family planning services, including all FDA-approved methods of contraception, prenatal care, and abortion for eligible women. To determine whether you qualify, contact the county social services office at. So not only are the women notified about the availability of abortion and other family planning services, but they're also given information about how to access them. This notice had to be posted in the waiting room, printed and distributed to all clients, or provided digitally at check-in, in English, and, has become somewhat important, in any other language required by state law, which in some counties, like where Los Angeles is, could be as many as 13 different languages. And also importantly, excluded from the definition of the covered facilities were over 1,000 clinics that were either operated by the federal government or California's own providers that provided a full range of family planning services. The other group of facilities referred to as unlicensed facilities, these are clinics that didn't have any kind of a license or a licensed medical provider, but they did do two of the following things. They either offered ultrasounds or sonograms or prenatal care to pregnant women, pregnancy testing or diagnosis, advertised or solicited to provide prenatal sonography, or staff or volunteers who collect health information from clients. In these clinics, the Crisis Pregnancy Center was required to provide a notice that it was not a licensed medical facility by the state of California and has no licensed medical provider who provides or directly supervises the provision of services. Now that notice with respect to the unlicensed clinics had to be not only provided on site, but in all advertising materials, had to be posted conspicuously at the entrance in at least one waiting area, and had to be done in at least 48-point type on a page that was at least 8.5 by 11, so that's what one would look like in English. But I was just curious what it would look like with 13 different languages.
Whoa, your props.
Google Translate did not have all 13 different languages listed in the opinion, but here's 10 of them.
Michael, you're not on camera right now.
Oh. So all of this would have to be provided not only in the clinic, but on any advertising. So there's a question at oral argument, if the clinic chose to place a billboard that said simply "choose life," 2 words, it was conceded at argument that those 2 words, "choose life," could have to be accompanied by all the text that I just showed you on my exhibit. Well, so there's a lawsuit. The Crisis Pregnancy Center sued. They allege that these notices violate their freedom of speech. District Court denied a preliminary injunction. Ninth Circuit affirmed, and the grounds for the Ninth Circuit's affirmance are important because they classified this as reasonable restrictions on professional speech. And so in the Ninth Circuit's assessment, this was justifiable because the speech regulations were evaluated on a lower level of scrutiny, and so they were justified. So Justice Thomas wrote for the court, 5-4 majority, reversing the Ninth Circuit. This would be, I think, a more predictable conservative majority joined by the Chief and Justices Kennedy, Alito, and Gorsuch. Justice Kennedy also wrote a concurring opinion. Justice Breyer wrote the dissent. And the basic reasoning, this is a First Amendment analysis by Justice Thomas. The basic core of the analysis is very straightforward. He has no problem characterizing this California law as a content-based regulation of speech that is compelling speech by the Crisis Pregnancy Centers. These are people who are providing their services almost expressly out of a viewpoint of being opposed to abortion, yet they are being required by the state to communicate not only about the availability of abortion, but how to obtain the abortion. And so Justice Thomas characterizes this as a classic compelled speech scenario, he spends a good part of the opinion attacking the Ninth Circuit's reasoning and saying that at least in this case, there's no justification for acknowledging a distinct category for professional speech and giving greater deference to restrictions on professional speech. This may actually be one of the most important parts of the opinion because it stands to affect other kinds of regulations, including regulations on the legal profession. I know Josh has written about this. But Justice Thomas writes at length and rather compellingly about the importance of protecting free speech within professions, particularly within the medical profession.
And legal.
Yeah, and legal. But he emphasized the importance of promoting free speech and open communication between doctors and patients. Talks about how restrictions on what doctors can tell patients has been a hallmark of many oppressive regimes such as Soviet Union, Nazi Germany, and so that's, I've kind of talked along already. Justice Kennedy's concurrence emphasized his concern about the apparent viewpoint discrimination at play here, that it really looked like that the focus was targeting the pro-life perspective of the crisis pregnancy centers. And Justice Breyer's dissent, not only does he take issue with Justice Thomas's analysis of the professional speech category, which Justice Breyer found as uncontroversial. And I think there was a theme this term of talking about weaponizing the Constitution. Justice Breyer said doctors do not have the right...
Weaponizing the First Amendment.
Well, okay, so doctors do not have the right to use the Constitution as a weapon, allowing them rigorously to control the content of reasonable conditions the state placed on medical practice. But I think Justice Breyer was really eager to make this more of an abortion case than a First Amendment case. Very interesting how he drew parallels to earlier abortion cases that approved, in the context of informed consent laws, cases that approved state laws that said if a woman comes seeking an abortion, the doctor has to inform her of the risks of the procedure and the availability of alternatives. From Justice Breyer's perspective, if that's okay, what's good for the goose is good for the gander. If somebody comes in seeking prenatal care, why shouldn't the woman be warned about the dangers of childbirth? Why shouldn't the woman be told about the availability of abortion? And so Justice Breyer sought to really make this into an abortion case, more of an abortion case, I think, than a First Amendment case. And I guess the last comment I'll make about that is I think it could be a preview to the extent people wonder about what's the fate of abortion jurisprudence under the new and changing Supreme Court. And people tend, at least in mainstream media, to rush to, will Roe versus Wade survive? Will it be overruled? I would expect that the far more likely thing we would see are the slight changes on the margins, where cases come up, testing the validity of particular kinds of restrictions, and if we're going to see any changes, it'll be, I would expect, little changes around the edges, at least for a while. I wouldn't expect a full frontal assault on Roe versus Wade anytime soon. So again, just such a privilege to be with you guys, and thanks for including me.
We already went late. Any questions? Jonathan? Yeah, go for it.
So using Trump versus Hawaii case, how do you think Trump will use, what is your predicament that Trump will use, and to what extent to stop that hurricane?
Oh, what a good question. So if you couldn't hear it, the question was this. To what extent will President Trump use the ruling in Trump against Hawaii with respect to asylum seekers, the caravanners, for example? The first off, come to my class tonight at 7:30. I'll probably answer this question in more detail. But the short answer is the asylum statute, right, operates differently than the statute issued in Trump against Hawaii. The issue in Trump against Hawaii was whether the government had to issue immigrant visas, right? Green card, for example. And there's a law that says you cannot discriminate with respect to the issuance of immigrant visas based on a person's nationality. No more quotas, for example. The court found that the travel ban, the entry ban, operated before you get to the visas, right? In order to get a visa, you have to be eligible for admission, right? So the universe of people who can get visas is those who are eligible to enter. The asylum issue is a little bit different because the asylum statute makes you eligible for asylum regardless of whether you can be eligible to enter. And you can seek asylum either overseas or at a port of entry. And there are very specific elements of asylum law that concern the port of entries of where you can seek entry and where you can seek asylum. So I don't think that Trump against...
Didn't it surprise you what I was expecting from the asylum-seeking / caravan proclamation to declare some sort of pre-port of entry zone?
You need Mexico's permission for that.
Well,
yeah.
But maybe he would
interdiction. Yeah.
Right. Yeah.
That was actually part of the proclamation.
The analog to wet foot, dry foot, except on land.
Yeah. So that was actually part of the proclamation to work with the Mexican government to interdict people on the Mexican side. If you stop them on the Mexican side, then you can have a policy. But unless Mexico cooperates, I don't think it's possible. But thank you for the question. Other questions? Yes, sir. Yeah. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state in which they reside. I think I got that one right.
Yeah.
It's in here. There's a long-standing debate over this question. I don't think it's a close call, but it's a fairly long-standing debate about what the phrase subject to the jurisdiction thereof mean. I think the better reading is that subject to the jurisdiction thereof refers to people who are subject to our laws. So if you come here and you're subject to our laws, you're subject to our jurisdiction. There's a very vigorous and vocal debate.
Unlike, to be clear, kids of diplomats, invading armies, and Indian tribes considered U.S. citizens until an act of Congress in 1932.
24. So but the other side of the debate is subject to our jurisdiction means subject to our rights. And the people who are not given the right to serve on juries, to vote, etc., are not subject to our jurisdiction. Again, as an original matter, there were people back in the 1860s who thought you had to be here with permission, a resident alien, to get birthright citizenship. And there were people who disagreed. So there always this dispute. This dispute goes back to the day. I think the better answer, based on a long-standing practice, which I think is important, is that the better view is those who are born here, subject to our laws, are citizens. Let me take a step back. It's very difficult being a common law professor in the last 18 months or so, because every day
5 years. I mean.
It's felt like a lifetime. I've gone gray already. Yeah, like every day, every week, every month, there's a storm of new constitutional questions, which we may have been thinking about for years, and suddenly come to the forefront with the tweet. With the tweet, it's unprecedented. Presindented, right? Unprecedented, right? But it's very difficult. That's why me and Ilya are hit the road. Ilya, how many schools have you visited? 70 schools this year?
School notes chapters. That includes lawyers chapters.
So he's in 70. He visits 70 federal chapters a year. I do about 40.
Can I chime in real quick?
Yeah,
on that?
please, Justice.
Not on the merits of birthright citizenship.
Please,
but I
God,
want to give a shout out actually to Professor Randy Barnett, because I hope none of you poison yourself. But one of the there timely argument about birthright citizenship said on offering opinions on questions like this until questions had an opportunity to percolate. There's an actual case. People have had an opportunity to argue about this. There's a really, really interesting, nuanced debate to be had about it. And people who thought that they had really, well-informed opinions, a month ago on this subject, I think a lot of people are stepping back. And I thought it was interesting to see Randy acknowledge that. Also, I think something that's really healthy for judges to try to keep in mind. we have opinions, or we think we have opinions about a lot of issues that might come up to us, but until there's a case, until you hear the arguments that people actually made, you don't know everything you need to know. And this is one I think that will benefit from more discussion.
Yes,
What do you think of Justice Scalia getting the presidential medal of freedom?
well, you have Elvis, right? You have Babe Ruth. You have Justice Scalia. You have Roger Staubach. Is that right?
Yes.
Who are the other ones? Mary Mailson. I don't know. Has there been a posthumous presidential medal of freedom? I don't know. I like Babe Ruth. I'm a Yankee fan, so I'm okay with that one. I don't care much for Elvis. Yeah, go.
The reason I asked is because you mentioned Antonin Scalia multiple times, and I'm not on us. But anyway, the other question was, what do you think about, it's not the recommendation of the Supreme Court, but what do you think of the kneeling during the anthem when it's like private business?
I'm sorry, you said kneeling for the anthem? Well, so I mean, the obvious answer is one's called state action, right? We talked about this last year. If a private business such as NFL wants to discipline its players for engaging in some sort of protected speech, they can do that as much as they wish. Now, if you have, and I've seen this, high school students getting disciplined for kneeling during the anthem in a public school, that's I think that's unconstitutional. You have a very famous case called Tinker versus Des Moines School District, which says if a student wants to engage in speech, doesn't cause a disruption, they can do it. I think kneeling during the anthem, you may not like it, but I don't think it disrupts the educational environment. One small caveat: there are state constitutions which guarantee right to free speech against private employers. I think New York, California, I think we talked about this last year, a couple states have this. So in theory, at least, a kneeling football player who's suspended could bring a cause of action under state law, although I don't know nearly enough of that to opine. Really?
I don't have anything to add to that.
We both do it professionally, so it's, like I can give his shtick, he can give mine. We can do it interchangeably. It's very good. Maybe one more question, let him go.
Although we do disagree on technology. I think PowerPoint is unconstitutional, at least in 90% of cases. Maybe Josh is the exception because he actually knows how to use this stuff, but most people just put up like a summary, a bullet point summary of whatever they're talking about. That's unconstitutional.
Mike?
Any opinion on potentially using social media, or to treat social media as the internet equivalent of a common carrier?
Billy?
Sure. I'm old enough to remember when Microsoft was thought to be a monopoly, and Netscape. Have you heard of Netscape? We're not professors. So who knows what a decade from now a seeming monopoly might be. This is the problem with antitrust law. I agree that government should step in if there's some sort of natural monopoly or regulated industry. Like there's a railroad that's engaging in anti-competitive behavior. You're not going to instantly have a competitive railroad right next to it that can compete with it or something. Are Facebook or Google or Twitter or whatever, are they more like Microsoft, or are they more like a railroad or a public utility, the water company or something like that? It's a tough question. I would rather, not, when the answer is not clear, I'd rather err on the side of not regulating.
Because you have the electric company, you have the waterworks, you have Reading Railroad.
That's right. That's right.
Last question, go ahead.
So last year you spoke about the difference between how you can have good law or good policy, and how sometimes you can have good law but bad policy, but you can still go forward.
Yeah.
Given how in recent days or even recent weeks, optics seem to be controlling how people view what is technically good law but bad policy, I'm wondering how that analogy plays given the current atmosphere we live in.
Well, look, I think whenever you have, especially in law school, if you have a professor or a guest speaker giving to you his or her theory of whatever, ask for examples of where their interpretive theory yields a result that they don't like as a matter of policy. And for me, because we've been arguing about various aspects of immigration a lot in the last 5 years, going back to Dakota, and then even before that, with SB 1070, the immigration space has really shown a lot of places where my legal and policy preferences or views diverge. Because, for example, I think most of SB 1070 was legal, and indeed the Supreme Court upheld all but 3 provisions of it, and yet I think it's bad policy that damages state economies and all sorts of things. DAPA and DACA, or at least certainly DACA, I think is good policy, but I don't think the president can rewrite a law on his own, which I think is what that was. Travel ban, I think, is at least 2.0, certainly 3.0 is legal, but I don't think it's both underbroad and overbroad as a matter of national security. So, you know, those are hints of examples, but the difference between law and policy is really conflated in many lawyers' minds, let alone the lay public. So it's definitely, you put your finger on an important issue.
I second Ilya. Ilya and I are somewhat unique in that we consistently favor policies that are unconstitutional, that we think are unconstitutional, and then we think policies that are really terrible ideas are lawful, and the travel ban is one of them. And if you're able to separate yourself from the legal issue, you're in a better place. If everything you think is a good policy is also constitutional, and everything is bad policy is also unconstitutional, you should probably reassess your beliefs. Yeah?
Given the conflict between both, have you ever questioned the validity of the Constitution itself?
Daily. Well, I mean, look,
Josh complains to me all the time about Rhode Island's ratification process.
You know, if you want to talk about the ratification, the Reconstruction Amendments, that was bogus, right? But I don't think there's consent and whatever. West Virginia is probably not a constitutional state. I mean, we can go down that rabbit hole pretty deep. You can't form a state from another state without consent. I mean, we can go down that hole.
I was in West Virginia just last week. Are you saying I was imagining things?
Country road. But let me actually.
I did drive home from there, in fact.
Let me ask. No, I do want to answer your question. I think it's a good question. A lot of the criticisms of constitutional law are really criticisms of the Constitution itself, and a lot of criticisms of our electoral system, the Senate, for example, are criticisms of the Constitution itself, and a lot of criticisms of the court works. Life tenure is a criticism of the Constitution itself. There were decisions made 220-something years ago by some, I think, very smart people, but they didn't perhaps make a decision with everything we know today. And maybe the answer is then to amend the Constitution. Maybe the answer is to have a constitutional convention, start from scratch.
That's not a crisis of legitimacy. That's You don't like what the current structure is, given what happens, you know, from the first principles or given what's going on in the country. And similarly, a lot of people throw around the idea of a constitutional crisis, like Trump firing Comey is a constitutional crisis. Trump firing Sessions is a constitutional crisis. There's a difference between a constitutional crisis
he asked for his resignation.
Right,
Come on,
and a political crisis, like Watergate, right? Really serious stuff. If Nixon had declined to follow the Supreme Court order to turn over the tapes, that would have been a constitutional crisis. Instead, it was just a political crisis leading to a resignation. I mean, the Constitution did fine in those terms. Similarly, you know, if you have one branch not following the other branch, or some indeterminate result that's causing some social rift, that might be a constitutional crisis. Otherwise, you have political stuff going on.
All right, we got to wrap because I have office hours. But if you have questions coming up, I'd ask them. Thank you all so much.